As part of its ongoing role in support of the judicial network in Central and Eastern Europe, the Seeley Institute presents a series of seminars on remote judging, where we discuss and suggest best practices to guide judges as they come to grips with e-justice, fair trial rights, and international standards.
I'm really delighted we've got two such fantastic speakers to start us off on our first module. So Andrea Huber, thank you for giving us your time. Andrea is head of the Human Rights Department at the OSCE Office for Democratic Institutions and Human Rights. She has a really rich expertise and background, previously a legal counsellor, previously worked at the Regional Higher Court in Vienna as a legal assistant to judges. She's held positions of legal officer and head of department in Vienna, Brussels, London, and also has worked for Amnesty International and Penal Reform International, and has been involved in the review process of the UN Standard Minimum Rules for the treatment of prisoners, the Nelson Mandela Rules, and has also recently been working on and produced the primer for courts during the coronavirus, which has just been published by ODIHR. Ilse Tremelka is a legal and policy officer at Fair Trials, which specialises in the right to fair trial, and her specific expertise around defence rights in criminal proceedings, which she's working on at the moment, particularly in the context of remote justice. She was previously senior legal advisor to the Latvian Parliament, representing that parliament before the Constitutional Court in Latvia, and has also worked for the Ombudsman in Latvia as well. And Fair Trials has produced some invaluable tools and guidance on these issues, some of which we put on the Resource Hub, but I do highly recommend that you go and look at them, because there seem to be quite a number of them coming out recently, and I'm sure there will be over the next few months. So we're really delighted that you've joined us tonight, and thank you for giving up your time. I'm going to hand over first to Andrea to give her presentation, and then Ilse. There'll be an opportunity for you to ask questions, and what I suggest you do is that you put the questions in the chat function as the presentations are being made, and then I'll collate them so that we can then ask them to Andrea and Ilse at the end of their presentations. So Andrea, I'll hand over to you first.
Thank you very, very much. I'm of course delighted to be here. It's so nice to be reunited with Seeley and with you, Rachel, and Ilse, with who we've cooperated so fruitfully during the lockdowns in order to get this primer out. So it's of course my pleasure to be re-invited to present it to you today, since it's been published. I think the division of labor is that Ilse will talk about the remote hearings and the fair trial implications. And then I will try to pick out from the report the things that are even more topical in the current circumstances. But just to start very, very briefly, who or what is ODIHR? So you may know or have heard of the Organization for Security and Cooperation in Europe. It's a regional intergovernmental organization, and it has a so-called human dimension working on human rights and democratic institutions. And that is the acronym for this office is ODIHR. We have a mandate to assist the participating states. There are 57 of them to implement their commitments, and this includes the rule of law and access to justice. And so the rule of law unit, where I used to work before, has a traditional focus on judicial independence, works with courts, and works on fair trials. Both in the interest in safeguarding the rule of law and access to justice for individuals, of course, translates into vital interest to retain functioning courts at all times, including during a pandemic or other states of emergency. This is vital, of course, so that urgent legal matters can be decided, but then from a more rule of law perspective, also, of course, courts are crucial so that they can scrutinize emergency legislation and provides effective remedies against excessive emergency measures in individual cases. And so this is where we were coming from in starting this portfolio. In my function, I have traditionally worked with judges associations, judicial councils, lawyers, and civil society organizations. And so when the pandemic hit and the lockdowns were imposed, I started to contact them to see how courts were still functioning and what issues they had. And this is where the idea of these consultations and desk research came from, that there were a couple of issues that were prominently mentioned as very challenging with different courts trying different things. And so we hired Rachel, which was an excellent idea. And she helped us do desk research and run a whole string of consultations with judicial stakeholders to collect information, to identify what the challenges are for courts and how they were handled in different countries, to exchange this information. Because of course, everybody was struggling with how to deal with this. There are no precedents for such a situation. And so eventually we put together this primer on the functioning of courts. It was finalized in August, but all the kind of final reviews and clearances meant that we could only put it on the website quite recently. I think it may have been shared with you, or I can put the link in the chat function. Unfortunately, we did anticipate at the time that it may not be a short-lived publication, although that would have been preferable, of course. But as we feared, these issues are pertinent again now in autumn and winter. And so hopefully at least maybe the collection of experiences is useful for you. The work is based on research and consultations between April and July, so mainly during the first lockdown and then the phase in which the restrictions were eased and courts started to reopen again. You will find in the publication chapters on kind of overall international law and safeguards during states of emergency, a chapter that looks at kind of the overall observations and challenges. I'll pull out some of them today. Then courts during the pandemic, how they deal with cases, how they prioritize cases, if they can deal with a smaller caseload overall, video conferencing and other IT solutions, health and safety of judges in the context of people being at courthouses, what measures to put in place in order to reduce the infection risk. And then, of course, the prioritization of cases that was specifically in the phase when the courts were able to reopen but had to deal with a backlog. And there's also a chapter on new cases and changes in the caseload. And finally, issues related to court management and judicial administration. In each chapter, you will find recommendations and you will find country examples that we described throughout to give a bit more of a concrete context of how different countries, but also courts or even judges have tried to solve these problems. There's also in annex a checklist of issues and a list of resources and publications, which you might find useful. So overall, of course, different countries have handled the situation very differently, but there are a couple of commonalities, and I probably will start with these first. So of course, as we all know, there was a speedy shift to work online in order to deal with the lockdown and social distancing. But this was not also well prepared, not always well prepared, and there was not always a legal basis for it, and it was not always consistently across the country or court. And I'm afraid this hasn't necessarily changed the second time around. Another issue, which I don't know how it has been handled now, I hope there have been some improvements, but at the time, there was a whole myriad of laws, regulations, policies, all adopted in short succession that were directed towards the judiciary. They were often inconsistent or even contradictory. They were amended frequently, and the judicial self-governing bodies and judges associations were not always consulted. And so this also meant that, they were not always workable at the practical level. Of course, for us, dear, from the democratic values perspective, I would also note that many of these emergency laws, and maybe also the ones that are being adopted now, are not necessarily adopted with the necessary parliamentary oversight and scrutiny. And some of them messed up or continue to mess up the separation of powers. So matters that were traditionally governed by the judiciary have all of a sudden been regulated by the government. And so we will have to look into whether that was sort of normalized and became a regular thing that even persists after the pandemic, which of course would not be a good thing. And of course, the responses to the COVID pandemic have to be seen on top of the challenges that courts have faced before. I don't need to tell you that there were already before financial constraints on justice systems, and then there are also some rule of law concerns in some OSCE participating states. From the international law perspective, I probably don't need to tell you this, but it is an obvious starting point. Whatever restrictions to human rights are implemented in a state of emergency must abide by international law, and that means they can only be temporary, they need to be necessary, and they need to be proportionate. And the important but also difficult thing is that what is necessary and proportionate changes over the course of time. And we've seen this, that constantly we're in a different phase of the pandemic. And so that also means that the restrictions to human rights and the changes to the functioning of the courts are changing. And so the question of necessity and proportionality of the measures constantly needs to be reviewed and adapted. So what was permissible maybe at the height of a lockdown may not be permissible in terms of international law later on. In all consultations that we held, one thing was very clearly always emphasized, that is the need for maximum cooperation of legal professions, in particular between judges and lawyers and their respective associations. So I hope that as we go forward in autumn and winter, that we have learned from this and that there is more of this cooperation. Overall, also in any law or policy, it is important that there is a balance between two conflicting requirements. So when you think about what cases to assign as urgent and to deal with as a matter of urgency as compared to those that are probably postponed, and also other decisions, you need on the one hand side rules and regulations so that these decisions are not arbitrary, so that there is clarity and predictability of what is going to happen, even what cases might be handled in remote hearings. But at the same time, not everything can be in every detail be regulated by law, because there needs to be a certain flexibility to decide on a case-to-case basis, partly in order to safeguard judicial independence, and partly because, after all, it is a matter of the specific case situation, and so it will depend on the circumstances of the case. Maybe to look a bit into the health and safety protocol chapter a bit more. To my knowledge, in most countries, courts now are open, even in countries with quite high infection rates, but I'm sure there are limitations as to which cases are operated in the courtroom. So when we were looking at this, we started by listing all the different individuals, the different stakeholders that in normal times come to courts. And so this is really an important kind of starting point to see what measures need to be put in place to manage the infection risk when these people enter the courthouse, move around in the courthouse, leave the courthouse, wait until they give a witness testimony, wait until the trial starts, etc. that includes lawyers, probation officers, etc. And of course, there needs to be rooms for confidential communication between parties and their lawyers. And usually there is a protocol for all of that, but in times of social distancing, it looks a bit different. The same, of course, or even more so for suitable courtrooms. Which courtrooms can you use in which you can fulfill a health and safety protocol that reduces the infection risk. And so we've collected a bit, although, of course, probably since we finalized the text, some new measures may have been introduced, from taking the temperature on entry to courthouses to increased cleaning protocols. In the summer, there was a lot of discussion to what extent air conditioning it was possible to use it safely or not, or which types of air conditioning. In some countries, it was a requirement to register in advance at the court when you were planning to go to attend a hearing. Of course, the seats in courtrooms were and are marked to indicate where individuals are allowed to sit, again, to provide for the social distancing. And then some courts, at least in the first wave, have limited the number of participants that can be present in the courtroom and have then maybe used a second courtroom in which the hearing was broadcast online in order to make the hearing accessible to the public, for example. It was also interesting that in some countries, the public health services took a role in assessing the health strategies at courts, even confirming which courtrooms it would be possible to use safely. But of course, it's not only about these measures to be put in place, but it's also important how to communicate them. So I assume this challenge poses itself again now. And again, there are very rapid adjustments that seem to be necessary in this pandemic, depending on the infection rates and the state policies overall. And so courts need to think about effective communication methods, how to communicate to the different stakeholders that usually would come to the court, what is expected to them, whether they are allowed to come or not, and under which conditions. So, for example, in Slovenia, individuals who were invited to attend court received quite detailed protocols together with this invitation to explain how this was going to be managed. In another country, WhatsApp was used to be in touch with lawyers frequently, and that then made it less necessary for the lawyers even to come to court. Of course, the constant question is who decides on these issues, who decides what measures should be taken for health and safety protocols, and also how to prioritize cases and all of these issues. So who decides really came up constantly in our research and in our consultations. It was quite different. In some, it was just the executive authorities with or without consultation of the judiciary, which of course is far from ideal. In other cases, the courts were more or less left alone, which is also not ideal. So I hope that maybe now we've also learned a bit from that, and that there's more balance between the role of the executive and the judiciary. Let me, just looking at the watch, and I want to leave some time for questions, but say a little bit about the definition of urgent cases, because the reduced accessibility of courts and maybe judges who are also not able to go to courtrooms as often as they used to means that cases will have to be prioritized, others postponed, others assigned to be dealt with by remote hearings, which is what Ilse will talk about. But how is this triaging of cases possibly done? And so while, of course, this was resolved very differently in different states, we found that there were a couple of commonalities, and we have put together some criteria that we found were consistently applied and did make a lot of sense in this regard. So one was, of course, the requirement of international law, and the second was the need to prevent irreparable harm. And those were really the two key criteria, I would say, from which you can deduct a lot of detail then. So matters related to the violation of rights, to which remedial action would likely then be ineffective if delayed. So that's pretty clear, fulfills both these criteria. For example, where individuals have specific vulnerabilities, where they're more likely to be at risk of physical or mental harm or neglect. So that could involve children, older persons, but also during the first lockdown, unfortunately, was established that women were much more vulnerable to domestic violence. Of course, all these criteria, it is important that they are objective, that they're fair, that they're clear, and that they're transparent. In the context of human rights obligations, let me just add that, of course, cases where individuals are deprived of their liberty need to feature on the list of these priority cases, in particular persons who have been arrested, because there is a fundamental right of them being brought before a judge, which is to be taken literally, to be brought physically before a judge. And then other procedures as well, dealing with unjustified detention should also be considered a priority, because the risk of infection in usually cramped conditions in prison is, of course, something to keep in mind in this regard. Of course, the question who determines the urgency is a matter that poses itself now. Maybe we can discuss this later. And maybe my very last bit will be on the new types of cases and the different case load. I've mentioned some already, the constitutional challenges to emergency legislation, remedies against criminal and administrative sanctions, where restrictions posed because of the pandemic were breached. That includes, for example, attending public assemblies. We saw and do see that quite a lot. And then in some countries, the problem of false information was also led to the imposition of sanctions, sometimes even criminal offenses for spreading false information. Privacy and data protection claims, certainly we did see a lot more during the first wave. And in terms of crimes, while certain crimes like burglary and assault happened at a reduced level, at the same time, we saw that cybercrime, domestic violence, and hate crimes, as well as fraud and corruption, is increased manifold. So those are a couple of things that we can learn from, I think, from the first wave of the pandemic. And of course, any questions, feel free to ask them.
Thank you so much, Andrea, for that extremely detailed and helpful presentation. I've just put the link to the primer on the chat function, but we've also got it on the course as well, the course hub. So we'll make sure that's visible for you there. I'm going to hand over to Ilse for her presentation, and then we'll take questions and answers for both of them afterwards. But if you have any questions, please do post them in the chat function. Ilse, over to you.
Yes, thank you. I will share a presentation because I was asked today to talk about legal standards, so it's a bit technical, probably. But of course, in the Q&A, we have also monitored the practice and how these standards are actually fulfilled in remote proceedings. So I'm happy to share that too in the Q&A, but this is just a short guide through the existing legal standards that basically where the law stands in remote hearings at this point. This is just very short. This is key sources of where we were looking at when evaluating where the law stands at. And so there's basically all the resources that talk about the right to a fair trial, and specifically right to be present in the trial and in a hearing. And these are the main ones where we found that there's some jurisprudence exists on that. So European Union, of course, there's charter standards, and there's a directive on the presumption of innocence and right to be present at trial. Council of Europe is, of course, the European Convention of Human Rights, and the courts case law is the most relevant at this point, because there is some case law under that, and the United Nations. I also added, it's technically ICC is not United Nations, and but there's some. There's one case that I highlighted in this presentation, but it could give a sort of idea of the direction how to evaluate whether remote proceedings are appropriate or not. So that's also a source of inspiration, if you will, to borrow from. But let's move on. So I think that as a starting point to evaluate whether remote hearings should be conducted or not, on what basis, and whether they are appropriate, is of course individual rights. A lot of the times what we hear now as a basis for conducting remote hearings, and also putting them into criminal procedure codes where they have not been provided before, is the efficiency concern, and also the length of the trial concern. But here, what is important to understand is also that the length of the trial is also a guarantee of fair trial. That is primary purpose of that guarantee is to benefit the defendant. So that's also something to take into account when choosing for remote hearing or trial in the presence of the accused versus their other fair trial guarantees. What is more important in that situation? That's also part of the evaluation. And of course, right to be present is very much connected to the right to a hearing from a legal point of view. So wherever there is a right of an open hearing, there's also a right for the defendant to be present. So these are very connected. And of course, there could be written proceedings. There could be other ways where the presence of the accused is not, where there's no right to be present, like in a cassation hearings on the points of law. Generally, that's not the case. But in the first instance, that's very much the case, that it's that the court deals with issues that require presence of the accused. And so far, this is just a summary. I will go in more detail into why those conclusions. But so far, looking at the law where it is, the presence in right to be present at trial means physical presence of the accused. It means that the normal sort of guarantees of fair trial would require that the accused has an option to be present in the courtroom. And it has mainly two reasons. One is, of course, the human dignity, everyone's right to have their day in court, face the prosecution, and also judge. But the second reason is more practical, and this is what the courts talk about, is effective participation and exercise of defense rights, which is a precondition. The presence of the accused is considered to be a precondition for effective exercise of those rights. And also, I will go into a bit more detail with that. Remote participation is, in essence, not a form of participation, but it's a form of presence, but it's a restriction of a right to be present. It's a lesser way of participating than actual presence, which is at the basis of the right to be present. So naturally, when there is a restriction, we have to think in terms of informed consent to waive that right to be fully present and according to the right. Or alternatively, if that remote hearing is imposed on the accused, if the court determines that, or state legislation imposes that remote hearing on the accused, then there has to be a legitimate reason for that. And also, of course, whenever there is a legitimate reason, aim, there has to be analysis whether that impacts on fairness of trial, of proceedings, or exercise of defense rights, proportionality, and specifically whether that's a found vulnerable defendant or not, is going to be lesser than whether that's proportional for that reason, for the aim and the public interest that these hearings are attempting to protect. This presentation will probably be given to you, so this is just the case law that I looked at. There's not much out there, so and there may be something that I've missed because it's very difficult to find at the moment. But these are the main cases that touch upon remote hearings in one or the other form, and where you can find some conclusions. There's also some case law from the ICC, International Criminal Court, on hearing witnesses on video link. Those I have not listed, but there is some case law on that. So physical presence versus remote participation, what to keep in mind. I mentioned some case law. I'm just looking at how much time I have. So one of the key cases that always gets mentioned is Marcello Viola versus Italy, and there the courts, it's European Court of Human Rights case, where the court concludes that that presence, right to be present in the hearing, it actually means right to be physically present, and this is the key conclusion that it's a sort of precondition for everyone charged with a criminal offense to be able to defend themselves in person, examine or have witnesses examined, and have assistance of an interpreter in the court. So difficult to see how these rights could be exercised without a person being present. So that is the starting point of the analysis of the court. And here is a decision that really goes into detail. It's an International Criminal Tribunal for former Yugoslavia case. For Rwanda case, where the accused, it was an interesting sort of precedent at that time, where one of the key witnesses in the case was detained in The Hague, but of course the court was in Arusha and in Tanzania. So prosecution asked for the witness to be heard via video link. The trial chamber, what they did is they concluded that they should hear the witness in person, but the accused couldn't be let into the Netherlands. So the accused and the prosecutor, to keep the equality balance, sort of, were ordered to participate from Arusha, while the trial chamber traveled to, was supposed to be traveling to the Netherlands to hear the witness in person. And of course, defense filed the appeal. And this is just a starting point as well of the analysis, where the accused said that he wants to be confronting the witness in person because it's ineffective for him to do so on video, in terms of seeing the demeanor of the witness, and it was a key witness. So he considered it wouldn't be that effective for him in such an important witness to do it on video. And one of the questions that was asked, whether right to be present is right to be physically present. And of course, the appeals chamber said yes, because that's, first of all, that's the meaning of the word. And also from the point of view of how it's phrased in the statute. So moving on, when there are restrictions, and it's not absolute, of course, it can be restricted, and we have seen now in the pandemic that there are circumstances where there's no other option and there has to be a remote hearing. So what to keep in mind when deciding on whether those restrictions, whether that's remote participation and remote hearings can be held. This is more, I think, also to keep in mind not only about emergency situations, which could be a bit more different, but also if remote hearings are to be held in the criminal procedure codes, and there is discretion to decide in what form to hold a hearing. Our first suggestion, of course, and this follows the law and usual guarantees in human rights law, is to that these hearings should only be and as a majority of the time should only be conducted with the informed consent of the accused, because that's essentially a waiver of the right to be present. So it needs to follow the usual rules that would apply, and safeguards that would apply to defendants when they give up a right of theirs in criminal proceedings. If, and that's a last resort sort of a situation, remote hearing is imposed by the courts, or in certain circumstances, I guess, by law, then we have to keep in mind that it is a restriction, and a restriction needs a reason, sort of legitimate aim. It could be because in previous cases, like Marcelo Viola, he was a mafia guy, and it was considered very dangerous and difficult to transport him in the appellate proceedings to the court. And there was a danger of attacks and getting in touch with former organized crime members of the organized crime ring, mafia. And so, having in mind all of those dangers, the courts did accept that there were security and safety reasons, and also need to organize the trial so that it doesn't take too long. So there was a legitimate aim. But of course, the court also said you have to make sure that even if that happens remotely, that defense rights do not suffer from that there is a due process, there's technology and all of the requirements for the defense to exercise their rights fully. So, and this is in essence what I've been saying was also reflected in this decision of the ICTR appeals chamber, where they said that there's two ways remote hearings can be conducted. One is the accused person can waive the right to be present and go and choose and opt for video. But when it's not the case, and for example, there's on the basis of substantial disruptions to the proceedings, it's required. Then proportionality principle and has to be applied, and also that reason why the objective that they're trying to reach by conducting remote hearings have to be sufficiently important and should not leave negative impact on the right to a fair trial and defense rights. So what to take into account when looking at whether remote hearings are or are not appropriate? So there's some suggestion in this case. So nature of the proceedings, whether those are detention proceedings, appellate proceedings, first trial, first instance. What's at stake for the defendant? We've heard during pandemic that 2 death sentences have been passed remotely. So I would say that stakes are very high in those cases, and that would not be appropriate to risk any negative impact to defense rights. any vulnerabilities and special needs. And it's very difficult, it's been very difficult to detect those special needs and vulnerabilities through camera. So I think that the special attention needs to be paid to that. In the end, I've copied in a link to a report from the UK Equality Commissioner, which highlights the problems of vulnerable defendants in remote hearings. They are less experience remote environment as more stressful and more confusing. So that's something to pay attention to. And of course, impact on defense rights. Some of that impact, here's another resource which agrees that remote participation is basically trial in absentia. But some of those concerns, then I'm running out of time, is one predominant concern is privacy of lawyer-client communications. I've mentioned case law, but there's also in our reports a lot of references. We received a lot of reports from lawyers saying there's no way to communicate between defendant and lawyer not being in the same room. Lawyers generally somewhere else, and defendants are either in detention or in another place. So there's very few chances of communicating, and where it's possible, it might not be confidential because of either prison administration people being present or court clerks if court technology is used. So that's one major concern. Another thing, of course, we've heard even from judges is ability to properly assess testimony of witnesses because of nonverbal communication, demeanor, and of course, also how to make sure that nobody is tampering with witnesses. There was a case in Ireland, I believe, where there was this murder case of a Garda, I think, and someone was testifying from the United States, and that testimony was interfered with. I haven't heard many more examples of that, but there has been one in recent months, so that's something to keep in mind. And some other concerns that we have drawn attention to more in our resources, but just to mention is the ability to follow the proceedings, because sometimes technology is simply not there. And where the technology is, maybe for a particular defendant, it's very difficult to switch between screens and to understand what's going on. Also, ability to present evidence. There has to be technology to do that, to review evidence in detail in remote hearings, and that's sometimes missing. And also ability to ensure proper participation of witnesses, where from, privacy concerns, and all of that. And of course, the public access to the hearings is also a major issue, at least in several countries at this point. Here's some useful resources that I've linked, but I think that this presentation will be shared with you. So that's going to be accessible for you. Thank you.
Thank you so much, Ilse. And, we're really happy you've gone over time, because I think all of the things that you're saying are extremely relevant and pick up on the points that have been discussed in the forum the last week or so. So extremely helpful, extremely appreciative of all that detail.
From the point of view of equality between prosecution and defense, I guess that would not raise much problems. But I think that what we have to look at is the effectiveness of the substance of the rights. For example, if the defendants are simply find it very difficult to follow who is who and what is happening in criminal in the case, when the entire courtroom is just squares of different people talking at different times. Also, I think one of the key factors that is very difficult is that the lawyer and the defendant is in different places, because that is the first there's a consultation on substance, like evidence, and there's exchange of information, but also that explanation of what is going on in the. So I think we have to look at the substance. I think it's the same from the right to be present and right to, at least, I don't know, confront the witnesses and all of that. There could be little change. But from the point of view of equality, of course, if everyone is remote, that's the only thing that gets solved in that. The right is to be physically present. That's what it is. That's what the understanding of the legal standard at this point is. It's right to be present physically. So the limited number of case law that we have says that it is a restriction for one or the other reason, that it could be accompanied by ineffectiveness of some other guarantees that come out of that. But it's not the same form of it's not a form of presence. Was it constructive participation or something like that? It's not presence. So I would say that it is still, video link is not presence. So in that sense, it's still a restriction. Of course, there can be, if there's brilliant technology to uphold all the other defense rights, then that could be taken into account, but it's not presence. I think it's the question of human dignity and effective participation. So there is a right to face, to be physically in the presence of the judge and of the prosecutor. So that's taken away, so there should be a courtroom. If it doesn't exist, then that's a different issue. But there should be a courtroom, and the defendant should have the right to be in the presence. To be, the state should make sure that there is a courtroom. Of course, in the emergency situations, we're talking about different regime. But if we talk about sort of peacetime, then the standard is that there should be a courtroom, and there should be a defendant's right to be in that courtroom and to be in front of a judge and beside a prosecutor. The waiver, as in every other right, I think, not everyone, but that right that doesn't oppose sort of a public interest. If there is a waiver, that's fine. Then a defendant should be able to choose to conduct video hearings. And I think at some point they could be even, like, if it's just a technical hearing on, scheduling or things like that, they should have a right to do so. But I think the problem is that we have to pay attention to is that it's really informed, that the defendants know what that means, about possible negative consequences, about, and there should be training and all of this, so that they are prepared and they know what that means to participate remotely. I think that's what we need to pay attention to.
Thank you. Andrea, did you have any comments you want to come back on in terms of things that Ilse said or any of the queries? So Andrea, over to you.
I got the sense when I heard the Judge Bistia, maybe there's the misunderstanding is that it's not about whether the defendant has the same means of communicating with the other participants in the court, but it is in a criminal trial, the only one who has human rights is the defendant. So the prosecutor's human rights cannot be breached in that situation. And so it's not the question of equality, that all are online and all have the same means to participate, but it's really that it's the defendant's human rights, which he or she may not be able to exercise in this way. And I think if we put ourselves in the position, to have a Zoom meeting, a work meeting, or with family, or a training like this, that's one thing. But imagine that your livelihood or your freedom depends on it. And then in India, you had even cases where the death penalty was imposed on a Zoom meeting. So imagine your life depends on it. And the one way you can interact with the court and make your case is through a little thumbnail video camera. So I think that we need to keep in mind why this is so important. But of course, if this is the only way to hold a hearing for months or years, then it's also the balance of having a trial in a reasonable time or having no trial at all. And so that is then becomes a question of balancing these rights. I just wanted to, there was one question early on about why is it so important that being brought before a judge actually happens in person, which I stressed. And Ilse focused on the right to be present during the trial. So maybe just one additional word on this. Why is it important to be brought before a judge after arrest, and why does that need to happen in person? That is something that the Human Rights Committee has clarified in a general comment. And the background is this, is for people who are held in pretrial detention, they're in the hands of law enforcement or penitentiary, and very often in many countries, criminal justice systems are very focused on attaining confessions at a very early stage in the procedure. And there will be a lot of pressure on the accused to confess, and very often even ill treatment or torture. And the only opportunity that such an accused has to actually voice this issue, that maybe a confession was not voluntary, is when he or she is in front of a judge, a person that is presumed to be neutral. But in a video conference, there will be the law enforcement people in the background, there will be the prison guards in the background. So this individual will never be able to raise any concerns, whether they relate to ill treatment or torture or any other concerns to the judge. And that's why it is presumed to be important that is brought before the judge is physically before the judge.
Thank you, Andrea. There were a couple of questions that maybe we can just touch on, if there is a need for a translator for a witness or for the defendant, and how that can work if they're in different or separate places, and any case law on that. Ilse, hand over to you first.
I haven't seen any case law, but I've seen concerns from practitioners where that has happened. So I think we've heard from translators that they find it difficult to also have there's delays, and if there's any kind of malfunction of equipment, that's very difficult. That's just basically, it's going to be disruptions. So ideally they are in the same room. Yeah, so I think that the main thing is, what also is important in remote hearings is that when there is a translation, then it's difficult to manage between people in the courtroom speaking really quickly and then translators struggling. So there's all sorts of problems with not being there and sort of having an overview of the situation. So I think in general it can be possible, but there's factors that make it very, very difficult. So ideally, and that should be a preference, that a translator, if needed, is together with the person who receives this translation, so that it's a higher quality and there's no interruptions, and that's why in remote hearings, when it's especially difficult to navigate, when there's a translation problem, it just makes everything so much worse.
If you have a defendant who needs a translation, you can have in Zoom or probably also other software, you can switch on the translation button, which you may still have technical issues. But of course, that then does not enable the defendant to have a conversation of the record with their lawyer. And so you would need a second stream for that or something. But it must be possible for the defendant to confidentially consult with his or her lawyer during trial. But of course, if there's just one translation stream, they would not be able to do that.
Thank you. And there was the final question, but I think we probably run out of time. But if you have just a couple of brief comments on this, are these requirements valid also for civil trials and any European Court of Human Rights decisions around remote participation in civil cases?
I did post 2 of the cases that were civil cases where the defendants were in detention and they were not brought to civil hearings, and the court suggested that one of the ways to ensure anyway to their participation would be through video links. So it seems like they're more ready to suggest that. But unfortunately, I haven't done much of research on that because we're working with criminal cases. So there could be, I doubt that a whole lot, but 2 of them are posted. But but I would say in terms of effective participation, pretty much the same standard should apply to also, because Article 6.1 also involves right to be present in the civil hearings.
Thank you. And Andrea, any final comments?
I think I have said a lot, but maybe just to flag that even in remote hearings, we established that what is really important as well is the kind of court etiquette in a remote hearing, because it's just very different. No, in a court, you know from the seating who everybody is, which you don't on a Zoom meeting. The little video cameras may switch place. How about the dressing, etc. So this may sound a bit petty, but I think it's really important to also keep an eye on the court etiquette so that you have the severity and the whole kind of weight of a court, and that it's clear who is who in the virtual courtroom if something like that takes place. So we've looked a little bit into that. There's certainly more room to expand on this, but you might be interesting to have a look at this content in the primer report.
Thank you so much, Ilse and Andrea, for all your time and those invaluable comments, which I think is a really brilliant basis for our discussion. And I think somebody's done a clap. I will do a clap. Unfortunately, we can't do any more than that. But thank you so much for your time. That is incredibly helpful.